In medicine, we rely entirely on this idea of an objective diagnostic standard.
Right.
Like if you come into the emergency room and your arm's hurting after a fall, we take an X-ray.
Yeah, that's the first step.
Exactly. We look at that film, and if there is, a jagged white line running right through the radiostone, the diagnosis is clear. It's broken.
Right. It's just a binary reality.
It is. You could have two doctors in that room who completely disagree on, I don't know, politics or religion or tax policy.
Sure.
But they will both look at that exact same piece of film and say, yes, that is a fracture. Here is how we treat it.
Because the anatomy doesn't change.
Right. It is deeply comforting because it's knowable.
Yeah.
The rules of human anatomy don't change based on who is wearing the white coat.
Yeah, that makes sense.
But when you step out of the hospital and you travel to Washington, D.C. and walk into the marbled halls of the United States Supreme Court, suddenly that X-ray machine seems completely broken.
Oh, totally broken.
We are looking at a diagnostic landscape where the exact same text, the exact same constitutional anatomy, produces wildly different diagnoses. And it depends entirely on who is wearing the black robe.
It is the absolute definition of diagnostic muddy waters.
Yeah.
And I mean, the stakes of those legal diagnoses are fundamentally shaping the country you live in.
Oh, without a doubt.
We are talking about the rules of how you vote, how your elections are funded, what you can do with your own body, and how your health is regulated.
It covers everything. So we've spent the week combing through a massive stack of legal analysis, historical data, and Supreme Court opinions.
A very tall stack.
A very tall stack. And we brought all these constitutional frameworks together to answer one fundamental question for you.
Right.
The mission for this deep dive is to look at the modern Supreme Court and ask, when the court decides the hardest, most fiercely controversial questions of our age, are the justices simply reading the law neutrally, or are they picking a political side?
Are they just calling balls and strikes, basically?
Exactly. Are they neutral umpires just calling balls and strikes based on the rule book? Or are there political actors wearing the costume of neutral law to enforce a preferred ideology?
And if we look at the timeline laid out in our sources, the pattern that prompts that profound question is just, well, it's stunning.
It really is.
Over a 2-decade span, roughly between the years 2000 and 2022, the Supreme Court fundamentally rearranged the American landscape.
Yeah, in massive ways.
They decided a disputed presidential election. They completely rewrote the rules of campaign finance, which unleashed billions of dollars into politics.
Right.
They dismantled the core enforcement engine of the Voting Rights Act, and they ended a 50-year-old constitutional right to abortion.
And here is the hook. The thing that really grabs you by the collar when you look at the raw data in these sources.
What stands out to you?
Almost all of these massive landscape-altering decisions were decided by a single swing vote. We are talking about 5-4 splits, and not just random unpredictable splits, but splits mostly along strict ideological lines.
Yeah, consistently conservative majorities.
Exactly. 4 of the 5 landmark rulings we are going to unpack today turned on just one justice. Just let that sink in for a moment.
It's wild to think about.
One single human being's interpretation of a document written centuries ago, changing the rights and daily realities for hundreds of millions of people.
Which is exactly why that charge of it's just politics in robes has gained so much traction with the public.
Right, because it feels arbitrary.
Exactly. When a decision swings on one vote, and that vote consistently aligns with a specific political ideology, it is very easy to conclude that the law is just an empty vessel for policy preferences.
Right off the bat, I think we need to set the rules of engagement for our deep dive today.
Very important.
Our goal is absolutely not to take a side. Right. We're not here to cheerlead for the political left or the political right. Our job is to give you the context you need to understand the forces at play.
We want to lay out both sides as strongly as possible.
Right. We are going to impartially examine the strongest critiques of the court, that very real view that it operates as an unelected super-legislature.
But then,
yes, we're going to genuinely, honestly explore the conservative rebuttal.
Right.
We're going to dive deep into originalism and textualism. We'll look at the defense that the justices were actually doing the exact opposite of playing politics.
That they were strictly enforcing limits.
Yes, enforcing constitutional limits. And deliberately handing these hot-button issues back to you, the voters, and to your elected legislatures.
And that is the crucial tension we have to navigate here.
Right.
The very same lineup of 5-4 justices that critics call a partisan right-wing voting bloc Well, defenders call them a principled majority engaged in a durable, consistent disagreement about constitutional method.
So we have to take the strongest version of both arguments seriously if we want to understand what is actually happening to American jurisprudence. So I want to start our journey with a case from the year 2000 that it feels intensely personal to me because of my background as a physician.
It's a tobacco case.
Yeah, it's a massive fight over tobacco. And it serves as the perfect entry point into how literal, strict interpretations of the written law can just violently clash with real-world life or death outcomes.
Right. FDA v. Brown and Williamson Tobacco Corp.
That's the one.
Decided on March 21st, 2000. And this perfectly illustrates the friction between a textualist reading of a statute and overwhelming public health imperatives.
So let's set the stage for that.
Yeah. To understand the stakes, we need to look at the historical context of the late 1990s.
Right, because for decades, the tobacco industry had publicly denied that nicotine was addictive.
Or that smoking caused cancer, yeah.
Even though their own internal documents, which were finally leaking out to the public at this time, showed they knew exactly how deadly and addictive their products were.
Right, the secret was out.
So enter David Kessler, who was the commissioner of the Food and Drug Administration. Under his leadership, the FDA conducts this exhaustive, multi-year investigation.
And they make a massive finding.
A sweeping, monumental finding. They officially classify nicotine as a drug.
Which is huge.
Huge. And logically following the science, they classify cigarettes and smokeless tobacco as drug delivery devices.
Right.
Because under the Food, Drug, and Cosmetic Act, which is the law that gives the FDA its power, the agency has the mandate to regulate drugs and devices to ensure they are safe for the public.
So they decide to step in.
Exactly. The FDA drafts regulations to step in and aggressively restrict the marketing and access of tobacco, especially targeting how it was sold and advertised to minors.
Which, from a purely public health perspective, I mean, that makes complete and total sense.
Total sense.
The mandate of the agency is to protect the public from dangerous drugs and faulty medical devices.
As a doctor, my visceral reaction to this is that it is a diagnostic no-brainer.
Right, obviously.
Tobacco is the deadliest consumer product in American history. It causes devastating illnesses, lung cancer, COPD, strokes, heart disease.
The list goes on.
It does. The idea that the federal agency explicitly tasked by Congress with regulating drugs and devices wouldn't be able to regulate a highly engineered, highly addictive drug delivery device that kills hundreds of thousands of people a year, it seems absurd.
It's a glaring contradiction.
It's like telling a cardiologist they can't treat a heart attack because the patient was wearing a blue shirt. It makes no medical sense.
But the tobacco companies, as you might expect, immediately sued.
Of course they did.
They claim the FDA was overstepping its legal bounds, and it goes all the way to the Supreme Court.
And what happened?
In a 5-4 decision authored by Justice Sandra Day O'Connor, the court strikes down the FDA's regulations. They ruled the FDA lacked the statutory authority to regulate tobacco.
5-4.
5-4. The FDA is flatly told they cannot regulate the deadliest product on the market under that specific 1938 Act.
See, I have to push back on the logic of this from the critic's perspective because it feels maddening.
I can hear the frustration.
Doesn't literalism become inherently dangerous when it blocks a public health agency from saving lives?
Well,
Because if the law explicitly says the FDA regulates drugs and devices, and nicotine is scientifically proven to be a drug, and a cigarette is mechanically a device, why on earth did the court say, no, you can't touch it?
right, looks counterintuitive.
Doesn't that look like the court just protecting a massive, wealthy, politically connected industry at the direct expense of public health? It feels like textual literalism produced a result that common sense and public health would never, ever choose.
And that is exactly how the critics framed it. It looks like a terrible real-world outcome.
Right.
But here is where we need to dive into the honest, conservative, textualist rebuttal and really define what textualism is.
Okay, lay it out for us.
Textualism is a legal philosophy that says judges should base their rulings strictly on the ordinary meaning of the text of a statute.
Just the text itself.
Right, rather than trying to guess the quote-unquote intent of the lawmakers or trying to achieve a preferred social outcome.
Even if that social outcome is saving lives.
Exactly. What's fascinating here is that the ruling wasn't about whether smoking is bad. The justices were not sitting up there arguing that cigarettes are healthy or that the FDA's science was wrong.
So what were they arguing about?
The ruling was strictly about the separation of powers.
Meaning, who actually has the power to make the rules in the first place?
Exactly. Justice O'Connor's majority opinion pointed out that over the decades, Congress had built a completely separate, distinct regulatory regime specifically for tobacco.
Oh, okay.
Congress had passed various laws requiring warning labels on cigarette packages, like the Federal Cigarette Labeling and Advertising Act.
Right, the Surgeon General warnings.
Exactly. They had banned cigarette advertising on television and radio. And crucially, whenever anti-smoking advocates went to Congress and asked them to explicitly grant the FDA the power to regulate tobacco, Congress repeatedly refused.
Oh, really?
Yes, repeatedly.
So the argument is that if Congress actually wanted the FDA to handle tobacco, they would have just written a one-page law saying so, rather than building this piecemeal framework of warning labels over 40 years.
Yes, and it goes even deeper than that.
How so?
The court pointed out a massive structural contradiction in the FDA's own logic.
A contradiction.
Under the Food, Drug, and Cosmetic Act, if the FDA finds a drug or device to be unsafe, the law requires them to ban it from the market entirely.
Right, like if a pacemaker is randomly electrocuting people, they don't just put a warning label on it, they pull it off the shelves.
Precisely. So the court reasoned, if the FDA truly had jurisdiction over tobacco under this act, they would be legally obligated to ban cigarettes entirely.
Because they are undeniably unsafe.
Right. But Congress had clearly structured the entire economy and dozens of other laws around tobacco remaining a legal sold product.
Ah. So you can't have both.
Exactly. Therefore, O'Connor reasoned, Congress simply could not have intended for the FDA Act to cover tobacco. Under textualism, an executive agency like the FDA cannot seize massive regulatory authority over a huge sector of the economy that the elected legislature deliberately withheld.
Even for a good cause.
Right. If Congress decided not to give the FDA that power, the FDA cannot creatively reinterpret a 1938 statute to suddenly grant themselves that power in 1996, no matter how noble or medically necessary the goal is.
I hear that defense, I really do. But it still feels like a massive loophole to me.
How so?
Well, the conservative defense is basically saying that allowing an agency to stretch an old law undermines democracy because it bypasses the elected representatives.
Right. Yes, that's their core argument.
They are basically saying, our hands are tied by the text. If you want this public health crisis fixed, go back to Congress.
And that is the core of the conservative judicial philosophy. The court forced the Democratic branch to act openly.
Right.
They told the FDA, you don't have this power, only Congress can give it to you. They are acting as a referee saying, you are playing the wrong sport.
Or using the wrong rule book.
Exactly. And if we look at the extrapolation and the democratic process, the sequel to this case actually proves the textualist point beautifully.
The sequel? You mean what happened after the ruling?
Yes, exactly. In 2009, 9 years after the Supreme Court slapped down the FDA, Congress finally passed the Family Smoking Prevention and Tobacco Control Act.
Okay, and what did that do?
That law explicitly, clearly gave the FDA the exact authority to regulate tobacco products that they had tried to seize earlier.
Which is an incredible point to consider for the defense.
It really is.
The system, from the conservative perspective, worked exactly as designed. The court exercised restraint, refused to legislate from the bench, handed the hot-button issue back to the legislature.
And eventually the democratic process resulted in a new law.
Right, a law that achieved the public health goal properly, with the full backing of elected lawmakers.
It forces accountability. The restraint forced the Democratic branch to take responsibility rather than letting an unelected agency stretch a statute and an unelected court validate that stretch.
Okay, I can concede that. It worked in the end.
Yeah.
But here is where we hit a wall. Forcing a public health issue back to Congress worked eventually.
True.
It took 9 years of political wrangling, lobbying, and debate, but it worked. As a doctor, I can tell you that sometimes a chronic condition gives you time to figure out a treatment plan. You can wait 9 years to properly regulate tobacco. But what happens when the court forces an issue back to the democratic process or relies on state mechanisms? But there is an unchangeable ticking clock.
Ah, I see where you're going.
You cannot wait 9 years to figure out who is going to be the president of the United States. You have to triage it immediately.
Yes.
Which brings us directly to the absolute constitutional crisis of the year 2000 election.
We are talking, of course, about Bush v. Gore, December 12, 2000.
This is one of those moments where, everyone who is alive and aware remembers exactly the confusion and anxiety of those weeks.
It was unparalleled.
It really was. It is election night. Al Gore, the Democratic vice president, and George W. Bush, the Republican governor of Texas. The entire presidency of the United States comes down to the electoral votes of a single state, Florida.
Right.
The margins are razor thin, a few hundred votes out of millions cast, and that automatically triggers a recount under Florida law.
And what follows is sheer chaos.
Sheer televised chaos. It is messy. It is televised 247, and it ends up right in front of the Supreme Court.
Right.
And in a 5-4 bore curiam decision, meaning a decision delivered by the court as a whole, unsigned by any specific justice, though split along those familiar ideological lines, the conservative majority halts the Florida recount.
And that decision effectively sealed George W. Bush's victory.
Yes, it did. So what was the reasoning?
To understand the legal earthquake here, we have to look at the rationale the court used, which was based on the Equal Protection Clause of the 14th Amendment.
Right. And here is the brutal critique of that decision. This is the reason why people point to this case and scream politics.
Let's hear it.
For decades, the conservative wing of the court had not shown much enthusiasm for expansive readings of equal protection. Usually, equal protection arguments were championed by the liberal wing in civil rights cases, arguing against systemic discrimination.
That's generally accurate.
But suddenly, to halt a recount that was potentially trending in a way they might not like, the conservatives reached for this equal protection theory.
Right. They dusted it off.
And worse, they explicitly wrote in the opinion that their reasoning was, and I quote, limited to the present circumstances.
Oh, that phrase. That phrase is the lightning rod.
I bet.
Limited to the present circumstances. It is arguably the most analyzed 6 words in modern Supreme Court history.
I have to tell you, as a doctor, that phrase sounds exactly like me telling a hospital board, look, I am going to authorize this highly experimental, unapproved, incredibly expensive treatment, but it is only valid for this one specific VIP patient, and no one else is ever allowed to have it.
That is a very potent analogy.
It looks completely unprincipled. Critics see that sentence as a blatant admission that the reasoning was not meant to be a real, repeatable legal principle.
Right, like a disposable ruling.
Exactly. It wasn't jurisprudence. It was a one-time key cut, specifically to open the Oval Office door for their preferred conservative candidate, and then they threw the key away so nobody else could use it. Doesn't that look like the ultimate proof of politics in robes?
It is the most cited piece of evidence by critics who believe the court's legitimacy is a facade. Absolutely.
So what's the defense?
Well, if we want to honor our rules of engagement, we must examine the neutral framework defense. We have to look at the reality on the ground in Florida at that moment because the chaos was unprecedented.
Okay, walk us through it.
The recount was not just messy, it was entirely standardless.
Define standardless in this context. What was actually happening in these counting rooms?
Well, we had different counties in Florida counting ballots by entirely different metrics. The voting machines had failed to punch all the way through the paper ballots, leaving us with the infamous hanging chads, dimpled chads, and pregnant chads.
Right, I remember seeing people holding ballots up to magnifying glasses on the news.
Yes. So one county, say a heavily Democratic one, might look at a ballot where the paper was just slightly dimpled and count it as a vote for Al Gore, arguing that the voter clearly intended to push it. But the county right next door, which might be Republican-leaning, might require the chad to be completely detached, hanging by no more than one corner to count as a valid vote for Bush.
Wait, so your vote literally had a different weight depending on where you stood in the state?
Exactly. The conservative rebuttal is that this genuinely, objectively violated the Equal Protection Clause. You cannot have a statewide, federally impactful election where the value and standard of a citizen's vote changes arbitrarily depending on which county they happen to live in. If the state is treating voters unequally, that is a real, substantive, constitutional problem that the Supreme Court is obligated to address.
Okay, I can actually see how varying standards across county lines is a complete constitutional mess.
Right.
You can't have 2 different definitions of a broken bone in the same hospital.
Exactly.
But here's my question. Why stop the recount entirely? Why couldn't the Supreme Court just act like the chief of medicine and say, okay, Florida, your standards are a mess. Here is the single unified standard for a hanging chad. Now go back and recount all the votes using this one rule.
That's a great question. Why halt the whole thing?
Yeah, why not fix it?
Because of the ticking clock you brought up earlier, there was a hard, immovable deadline approaching.
What kind of deadline?
Federal law provided what was called a safe harbor deadline for states to resolve their own internal election disputes and lock in their electors. If a state finished its recount by that date, Congress was legally bound to accept those electoral votes without challenge. For the 2000 election, that safe harbor deadline was December 12th.
Wait, December 12th. That was the exact same day the Supreme Court issued its decision.
Precisely. The court looked at the calendar and determined that even if they ordered a unified standard, making it a lawful, constitutionally sound statewide recount, it was physically and legally impossible for Florida to execute a statewide recount in a matter of hours before the safe harbor deadline expired.
Oh, I see.
And Florida state law itself, as interpreted by its own legislature, had indicated a strong desire to take advantage of that safe harbor provision to ensure their voters weren't disenfranchised by Congress.
So the defense is that the court didn't magically pick George W. Bush.
Right.
They simply declined to use their legal authority to rescue a messy, unconstitutional recount that state law had already run out of time to fix.
Exactly. The argument is that the clock beat Al Gore, not the justices.
Wow.
The justices were just the ones who had to point the clock and say, time's up.
And what about that controversial phrase, the limited to the present circumstances part?
Right. Defenders argue that was actually an act of judicial modesty, not bad faith.
Modesty. How is that modest?
Well, the court was saying election mechanics are incredibly complex and state laws vary wildly. We are solving this specific, unprecedented crisis in front of us to prevent a constitutional meltdown.
Right.
But we don't want lower courts using this highly unusual, chaotic situation to micromanage every local, mayoral, or city council election dispute from here on out. They were trying to fence in the chaos, not write a sweeping new law of equal protection.
It is a fascinating defense. You either see the decision as a partisan hit job masked in temporary disposable legal theory,
or you see it as a reluctant court stepping in to apply necessary equal protection to a broken system right before the buzzer sounded.
Yeah. But either way, the impact is undeniable. Bush v. Gore essentially decided who would occupy the Oval Office.
Absolutely.
It shaped American foreign policy, the wars in the Middle East, and the very makeup of the Supreme Court itself in the years to come.
It did. It showed the awesome, terrifying power of a single vote on the court to shape the entire executive branch.
And what's incredible is that a decade later, the court shifted from deciding the outcome of a specific election to deciding how elections themselves are funded and fought.
A huge shift.
They moved from the mechanics of counting votes to the mechanics of democracy itself, opening a massive, still raging debate about the very definition of speech.
Let's look at Citizens United.
Yes.
Decided January 21, 2010. Citizens United v. Federal Election Commission. Another 5-4 decision, this time authored by Justice Anthony Kennedy.
You know, if Bush v. Gore is the case people remember for the sheer drama and the hanging chads, Citizens United is the case that fundamentally altered the daily, invisible reality of American politics.
It changed everything about campaign finance.
It really did. In this 5-4 split, the court ruled that the government cannot ban independent political spending by corporations and unions. This is the decision that birthed the era we live in, now the era of superpays, dark money, and unlimited independent expenditures.
And the backlash to this was immediate, ferocious, and incredibly sustained.
Oh, yeah.
Even the President of the United States, Barack Obama, publicly rebuked the justices during his State of the Union address while they were sitting right in front of him.
Absolutely ferocious. Let me outline the critique, because it is something you hear constantly from voters across the political spectrum.
Go for it.
The critique is that by treating corporations as speakers with First Amendment rights, the court essentially handed the loudest megaphone in the country to concentrated wealth.
Right.
It feels like the court looked at democracy and said, yes, your vote as an individual citizen counts for one, but this billionaire's multinational corporation gets to spend $50 million blanketing the airwaves with attack ads to drown out your voice.
It feels wildly unbalanced to people.
Exactly. Critics argue this completely corrupts the democratic process by equating money with speech. Because if money is speech, then the rich have more free speech than the poor.
It is a powerful, intuitive critique, and it resonates deeply with how many people feel about the influence of money in politics.
So how on earth does originalism defend that?
Well, to understand the court's ruling and why 5 justices believed they were saving the First Amendment, not destroying it, we have to pull back from the broad anxiety about superPICs and look at the literal facts of the case that arrived at the court's doorstep.
Okay, originalism again. Walk us through the facts. What actually triggered this case?
The case started because a conservative nonprofit group called Citizens United produced a documentary film.
A movie.
A movie. It was called Hillary, the movie, and it was highly critical of Hillary Clinton, who was running for president in the 2008 primary.
Okay, seems like a pretty standard political attack piece.
Yes, but federal campaign finance law, specifically the Bipartisan Campaign Reform Act, better known as McCain-Feingold.
Right, I remember that one.
McCain-Feingold made it a criminal offense for corporations or unions to use their general treasury funds to broadcast electioneering communications within a certain window, usually 30 or 60 days, before an election.
Wait, so a group of citizens formed a nonprofit corporation, made a movie criticizing a politician who was running for the highest office in the land.
Yes.
And the federal government said, if you show this movie to the public, you are committing a federal crime.
Yes, that was the law. And during the oral arguments at the Supreme Court, it produced one of the most stunning exchanges in modern legal history.
What happened?
The conservative justices started pressing the government's lawyer, asking how far this power went.
Okay.
They asked, under your interpretation of the law, if a corporation published a 500-page book and it had one single sentence at the very end endorsing a political candidate, could the federal government ban the publication of that book?
And what did the government say?
The government's lawyer, forced to follow the logic of the statute, had to concede that, yes, the government would literally have the power to ban that book.
Wow. Ban a book in the United States of America.
Exactly. And that concession effectively doomed the government's case.
I can see why.
Under an originalist and textualist view, political speech, criticizing politicians, debating who should hold power, organizing to oppose the government is the absolute beating heart of the First Amendment.
Right.
It is the very core of why the amendment was written by the founders. So Justice Kennedy and the conservative majority looked at this and said, criminalizing a political film or potentially banning a book just because the publisher is organized as a corporation.
That's blatant censorship.
Yes, it is the exact literal censorship the First Amendment was written to prevent. You cannot let the government decide who is allowed to speak about politics and who isn't. The First Amendment protects the speech regardless of the speaker.
Okay, I see the First Amendment crisis there.
Yeah.
Prior restraint on a book or a movie is terrifying.
Right.
But here is where my pushback comes in. Sure, protect the documentary. Say that McCain-Feingold went too far in that one specific instance. But did the court have to blow the doors off the entire campaign finance system?
Well,
Because by ruling so broadly, they allowed megacorporations and billionaires to funnel unlimited money into super PACs and 501c4, which is what we call dark money, because they don't have to disclose their donors.
sure.
Did they have to go that far? Doesn't that distort the system so wildly that the average voter becomes irrelevant?
The conservative rebuttal is that the First Amendment does not allow the government to level the playing field by silencing voices.
Level the playing field.
Yes. Justice Kennedy explicitly wrote that the government cannot restrict the speech of some elements of our society in order to enhance the relative voice of others.
Oh, wow.
The remedy for speech you don't like, or speech that is heavily funded, is more speech and disclosure transparency about who is funding it.
But the dark money groups don't disclose.
And the court noted that. The court actually upheld the disclosure requirements of the law.
They did.
Yes, they said Congress is fully within its rights to pass strict laws demanding that every corporation and super PAC disclose exactly who their donors are.
So why don't we have that?
The fact that Congress hasn't passed airtight disclosure laws is a failure of the legislature, not a failure of the First Amendment.
I see.
Furthermore, it's vital to note that this ruling protected labor unions exactly as much as it protected corporations. Unions also gained the constitutional right to make unlimited independent expenditures to support pro-labor candidates.
So the argument is that the court was just reading the First Amendment neutrally, that Congress shall make no law abridging the freedom of speech. Means exactly what it says.
Right.
And if we don't like the fact that billionaires can buy up all the ad time, it's not the court's job to fix it.
Precisely. Defenders of Citizens United insist that if the public truly wants money out of politics, they need to do the hard work of democracy.
Which is?
They need to pass a constitutional amendment to change the First Amendment or pass new comprehensive disclosure legislation. It is not the job of unelected judges to creatively rewrite free speech law just to reach a preferred egalitarian outcome. That would be the very definition of legislating from the bench.
It is the ultimate clash of perspectives. Critics see a court willfully blinding itself to the corrupting systemic influence of massive wealth, while defenders see a court drawing a hard, necessary line against government censorship of political films and books.
And neither side is really backing down from those views.
No, they aren't. Citizens United sparked outrage because it altered the mechanics of democracy regarding money. But 3 years later, the court altered democracy even more directly.
Let's get into it.
They took on a cornerstone of the civil rights era, and they did it based on the argument that the data was out of date.
That brings us to Shelby County v. Holder, decided in June of 2013.
Let's set the scene for this one. Chief Justice John Roberts writes the opinion for a 5-4 majority, and the case is about the Voting Rights Act of 1965.
A massively important piece of legislation.
Truly, to put this in context, the Voting Rights Act was born out of the blood and sacrifice of the civil rights movement, the marches in Selma, the systemic, violent disenfranchisement of black voters in the Jim Crow South.
Right.
It is widely considered one of the most successful, most important pieces of civil rights legislation in American history. Specifically, in this case, the court struck down Section 4B of the Act.
This is a highly technical but absolutely vital piece of the law.
Explain it for us.
Section 4B was the coverage formula. It was the mathematical geographical formula used to determine which specific states, counties, and local jurisdictions had a history of severe systemic voting discrimination.
Okay, so it flagged the bad actors.
Exactly. If a state fell under this formula, which included mostly states in the Deep South like Alabama, Georgia, and Texas, but also parts of other states, they were subjected to a process called preclearance under Section 5.
Meaning they couldn't just change their voting laws on their own?
Right.
They had to ask the federal government, either the Department of Justice or a federal court in D.C., for permission or preclearance before changing anything.
Anything related to voting, yes.
I mean, anything from instituting a new voter ID requirement down to moving a local polling place from a school to a church.
Correct. The federal government acted as a chaperone to ensure no new discriminatory laws were passed, intentionally or otherwise.
So what did the court actually do?
By striking down the coverage formula in Section 4B, the court didn't officially declare preclearance itself unconstitutional, but they left it with no live coverage map.
So it was useless.
Without a formula to determine who is covered, preclearance was effectively paralyzed. It stopped functioning entirely.
And the critique of this decision is perhaps best summarized by Justice Ruth Bader Ginsburg in her famous blistering dissent. I want you to imagine her analogy because it is absolutely brilliant in its clarity.
Let's hear it.
She wrote that discarding preclearance, because it was working and because voter discrimination had decreased in the South, is, quote, like throwing away your umbrella in a rainstorm because you are not getting wet.
It is one of the most memorable and frequently quoted analogies in modern Supreme Court history.
Because it perfectly captures the frustration. The critique is that the Voting Rights Act was the only thing keeping the reign of discriminatory laws at bay.
Right.
And critics point out that literally within hours of the Shelby County decision coming down, previously covered states immediately moved to pass strict voter ID laws, purge voter rolls, and close polling places in minority neighborhoods.
The reaction was instant.
Texas announced a strict voter ID law would go into effect immediately.
Yeah.
North Carolina passed a sweeping election overhaul that a later report said targeted black voters with almost surgical precision.
Wow.
To critics, this fueled a narrative of raw politics. The conservative majority struck down a protection for minority voters, and conservative state legislatures immediately capitalized on it to alter the electorate in their favor.
It looks to the critic like a coordinated ideological effort. The court opens the door, and the state legislatures walk right through it.
Exactly.
But again, we must turn to the legal doctrine that guided Chief Justice Roberts' majority opinion to understand why 5 justices thought this was constitutionally required.
Okay, what's the doctrine?
The principle here is rooted in federalism. It's called equal sovereignty.
Equal sovereignty of the states. Explain how that applies here.
Yes. The Constitution treats all 50 states as equal sovereigns. The federal government cannot treat Texas or Alabama as second-class states, subjecting them to intense federal supervision while ignoring New York or Massachusetts, unless there is a compelling current reason to do so.
Okay.
The conservative rebuttal centers entirely on the data and the passage of time. The coverage formula that the court struck down in 2013 was originally based on data from the 1960s and early 1970s.
Wait, really?
Yes. It was triggered by things like whether a state used a literacy test in 1964.
So by 2013, the data anchoring the formula was nearly 50 years old.
Exactly. Roberts argued that our country has changed dramatically since 1965. Minority voter registration and turnout in the covered states had approached, and in some cases even exceeded, white voter turnout.
Okay. So
There were black mayors in major southern cities. The argument is that Congress cannot single out specific states forever, putting them under federal chaperonage based on 50-year-old sins without updating the evidence to reflect current reality. It violates the basic constitutional structure of states' rights.
So if we compare this to the FDA tobacco case we talked about earlier.
Yeah, good comparison.
Roberts didn't say, pre-clearance is unconstitutional forever, we are killing the Voting Rights Act. He struck down the old formula and essentially invited Congress to do its job.
Yes.
He said, write a new formula based on modern data, find out where discrimination is happening today, and it will be completely constitutional.
That is the pivotal point of the defense. He explicitly left the door open for the legislature. He said, pass a law that reflects today's data.
But here is the tragic contrast that jumps out at me. In the FDA case, Congress eventually stepped up and passed the Tobacco Control Act.
True.
In the Shelby case, Congress completely failed to act. They were too paralyzed, too polarized to write a new coverage formula, so pre-clearance remained dead.
And that's where we are today.
But it raises a really uncomfortable question for the critics of the court. Is it fair to blame the Supreme Court for Congress's paralysis?
It's a tough question.
If the court's job is to say, constitutionally, you cannot use 50-year-old data to punish a sovereign state, and Congress refuses to do the hard work of gathering new data and passing a new law, is the resulting loss of voting rights the court's fault or the legislature's fault?
That is the core defense of the court's legitimacy in this case. The decision returned the question to the body the Constitution assigns it to, the United States Congress.
Right.
The fact that Congress is profoundly broken, hyper-polarized, and incapable of passing major legislation does not mean the Supreme Court should ignore the constitutional principle of equal sovereignty just to cover for Congress's ineptitude.
So the court's basically saying, don't look at us, look at them.
Right. The court's job is to apply the law, not to act as a backup legislature when the real one stalls.
It's a stark reality. In Shelby, discarding a formula based on old facts caused a national uproar and changed the mechanics of who gets to vote.
Yeah, it was huge.
But what happens when the court doesn't just discard an old data formula, but discards an entire half-century of relied upon, intensely personal constitutional rights? This brings us to the seismic shock of 2022, the earthquake of Dobbs.
Dobbs v. Jackson Women's Health Organization. We have to tread carefully and thoughtfully here, keeping our promise to remain measured and objective, because no case in modern history has generated more raw emotion.
Absolutely.
And both sides hold deeply sincere, entirely opposite convictions.
Let's walk through the timeline, because the buildup to this decision was unprecedented in American history.
It really was.
In early May 2022, the news organization Politico published a leaked draft of the majority opinion. This was an absolute institutional shock.
The Supreme Court prides itself on absolute secrecy. It is a vault.
Right. Seeing a full, unredacted draft opinion before the decision was handed down shattered that norm and set the country on edge for weeks.
It's a very tense period.
Then, on June 24, 2022, the official ruling comes out. The court voted 6-3 to uphold a Mississippi law that banned abortion after 15 weeks of pregnancy.
Okay.
But, far more consequentially, they voted 5-4 to completely overrule Roe v. Wade and Planned Parenthood v. Casey.
It's important to look at the breakdown of that vote.
Let's hear it.
Chief Justice Roberts concurred in the judgment to uphold the 15-week ban, but he notably refused to join the 5-4 majority that overturned Roe outright.
He wanted a narrower ruling.
Yes, he argued for a narrower ruling, warning against taking such a massive disruptive leap all at once. But Justice Samuel Alito wrote the majority opinion for the other 5 conservatives, officially ending the federal constitutional right to abortion.
Keeping our tone highly measured, we have to explain why this case, more than any other, cemented the politics in robes critique for millions of Americans.
Right.
It comes down to confirmation hearings and the concept of precedent. Over the years, several of the conservative justices in the majority have been asked explicitly about Roe v. Wade during their Senate confirmation hearings.
Yes, those hearings were heavily scrutinized.
And several had described it as settled precedent or the law of the land,
which gave the public and many senators the distinct impression that the right was secure, even if those justices personally disagreed with it.
Right. And the critique is that the moment the court's personnel changed, specifically with the addition of 3 conservative justices appointed by President Donald Trump, that 50 years settled precedent vanished overnight.
Almost instantly.
The text of the Constitution hadn't changed in those 50 years. The biological facts of human reproduction hadn't changed. The only thing that changed was the political makeup of the 9 people sitting on the bench.
And that's hard for people to swallow.
For critics, this is the ultimate, undeniable proof that outcomes track personnel in politics. They argue that overturning a half-century precedent that millions of women had relied on to structure their lives, their health, and their families severely strains, if not completely shatters, the court's claim to be above the political fray.
It looks like a political promise fulfilled by a newly appointed majority.
Yes, exactly.
It is a profound critique regarding reliance and the stability of the law, because if a right can be erased just because the roster changes, what does the law even mean?
Right. But to truly understand the court, we must provide the honest conservative rebuttal.
Which is rooted as deeply as possible in the philosophy of originalism.
Okay, unpack that for us.
For the conservative legal movement, Roe v. Wade was not just a case they disagreed with on a policy level. They viewed it as constitutionally ungrounded from the very day it was decided in 1973.
Break that down for us. What does ungrounded mean in this constitutional context?
Justice Alito's majority argument focused squarely on the text and the history of the Constitution. The word abortion does not appear anywhere in the constitutional text.
Okay, that's true.
Now, both sides acknowledge that the Constitution protects many rights, not explicitly named in the text, under the Due Process Clause of the 14th Amendment.
Things like the right to travel or the right to marry.
Right. But originalists apply a very specific test. They argue that for an unnamed right to be protected by the Constitution, it must be deeply rooted in this nation's history and tradition.
So they look backward to see what was considered a right when the amendment was written.
Exactly. Alito conducted an extensive historical analysis and concluded that at the time the 14th Amendment was ratified in 1868, abortion was widely criminalized across the vast majority of the states under common law. Okay? Therefore, he argued, a right to abortion cannot possibly be considered deeply rooted in the nation's history and tradition.
So the conservative view is that the original Roe Court in 1973 essentially invented a right out of thin air because those particular justices preferred that policy outcome.
That is exactly their view. From the originalist perspective, Roe v. Wade was the ultimate act of judges playing politics. It was the original sin of judicial overreach.
Wow.
And therefore, the defense argues that overturning Roe, correcting a wrongly decided case that had no basis in the text or history, is the opposite of politics.
Interesting.
It is a painful, controversial, but necessary return to the actual law. It is restoring the Constitution to its original public meaning.
And there is a second vital part to that defense, isn't there?
Yeah.
About where the power to decide this issue goes next.
Yes, and it's crucial to understanding the legal framework. Dobbs did not ban abortion nationwide.
Right, that's a common misconception.
Yeah. The Supreme Court did not outlaw the procedure. What the 5-4 majority did was return the issue to the states and to the elected representative.
Right back to the voters.
The conservative defense is that on a moral, ethical, and medical question, as profound and fiercely debated as abortion, where Americans hold completely incompatible but utterly sincere views, 9 unelected judges sitting in Washington shouldn't dictate the answer for all 330 million people.
The democratic process should.
Exactly.
Oh.
Let the voters of California decide the laws for California, and let the voters of Mississippi decide the laws for Mississippi.
It really highlights the fundamental divide in judicial philosophy.
It does.
The liberal dissenters, Justices Breyer, Sotomayor, and Kagan, argued passionately that fundamental human rights shouldn't be subject to a state-by-state vote. A right is a right, regardless of what state line you cross.
Right.
But the conservative majority argues that if the right isn't actually in the Constitution, the court has no business deciding it, and to do so is to steal power from the voters.
We can acknowledge that both sides of this divide hold sincere, opposite convictions.
Absolutely. And hopefully, laying out the legal philosophy leaves you, the listener, better equipped to judge the reasoning for yourself.
But while the justices debate high-minded judicial philosophy, original public meaning, and history in their chambers, the public is out here watching the real-world results of these rulings.
Exactly. You can talk to a patient about the complex cellular mechanics of an autoimmune disease all day long, but all the patient knows is that they are in pain.
That's a great way to put it.
You can talk about equal sovereignty and textualism all day long, but the public sees the loss of voting protections, unlimited corporate money flooding their local elections, and the end of a 50-year right to bodily autonomy.
Right.
And the public's reaction to this string of 5-4 decisions has triggered an undeniable crisis of confidence.
It really has.
Which brings us to our final section, legitimacy on trial. Let's look at the polling, the polarization, and the role of the court in modern America.
The data in our dossier from Gallup and the Pew Research Center is stark. Between 2022 and 2024, following the Dobbs decision, public approval of the Supreme Court plummeted to historically low levels.
How low?
Gallup tracked approval hovering around 40%, which is a modern nadir. Disapproval hit record highs across the board.
Focusing strictly on the jurisprudence and these massive ideological splits, we have to analyze these numbers. Are they a symptom or are they a verdict?
What do you mean by a verdict?
I mean, I have to push back on the idea that the court can just ignore these polls. Alexander Hamilton famously wrote in Federalist 78 that the court has neither force nor will, but merely judgment.
Right. They don't have an army.
They don't have an army. They don't control the budget. They rely entirely on the public's belief in their authority.
True.
If an institution relies entirely on legitimacy, doesn't a 40% approval rating definitively prove the court has lost its legitimacy? If the people don't believe you are neutral, you aren't neutral.
That is the verdict argument. It says the court has broken the public trust through ideological overreach. No. But the counter-argument asks us to look at the broader context of American society right now. Does this 40% approval genuinely reflect outrage at specific, flawed legal methodologies like originalism?
Okay.
Or is it merely a symptom of our intensely polarized social environment and siloed media? We live in an era where trust in all institutions, Congress, the presidency, the media, the medical establishment, is at rock bottom.
That is definitely true.
If the country is split 50-50 on every major cultural and political issue, and the court is frequently called upon to decide those very issues, isn't it mathematically inevitable that they will deeply anger half the country with every single ruling?
That is a very fair point.
Yeah.
If the court rules to protect abortion rights, they enrage the political right. If they rule against it, they enrage the political left.
There is no middle ground in a binary decision.
So maybe the approval rating isn't a measure of their legal accuracy, but just a measure of how angry the losing side is in a hyper-partisan era.
Exactly. Defenders of the court argue that legitimacy isn't a popularity contest.
Right.
True legitimacy, they say, is having the courage to make the legally correct, constitutionally grounded decision, even when you know it will tank your approval ratings in the short term.
Even if everyone hates it.
Right. Handing a hot-button issue back to a polarized legislature is always going to make people angry because it forces the public to actually debate the issue rather than relying on a judicial decree. But originalists argue it is the only constitutionally sound move.
So we have to synthesize this entire deep dive. We started with a fundamental question. Do these 5-4 splits prove politics in robes, or do they prove a genuine, durable disagreement about constitutional method?
And we have seen the strongest versions of both arguments today.
We have.
Critics look at the sheer power of the single swing vote and see outcomes that perfectly seamlessly track conservative policy goals.
Protecting corporate speech in Citizens United.
Gutting the Voting Rights Act in Shelby.
Overturning Roe and Dobbs.
And installing a Republican president in Bush v. Gore.
To the critic, the methodology of originalism is just a convenient tool deployed to reach those partisan ends.
But the conservative defense offers a consistent philosophical thread through all of them. The court is refusing to act as a super legislature.
Right.
They refuse to let the FDA write its own laws without Congress. They refuse to rewrite the First Amendment to fix campaign finance.
They refuse to let 1960s data dictate modern state sovereignty in Shelby.
And they refuse to uphold a constitutional right they believed was invented by previous judges in Dobbs. In every case, they argue they are being a modest umpire, delegating policy back to the elected branches where it belongs.
But the critic's final, lingering counter is this. Is the act of returning it to the legislature truly the act of a modest umpire?
That's the big question.
Or is it a calculated policy choice dressed up as modesty, because the justices know exactly who the winners and losers will be when they hand it back to highly gerrymandered or paralyzed state legislatures?
That is the ultimate tension.
We've taken quite a journey today. We started with a physician's frustration over the FDA and tobacco, watching a deadly product temporarily escape regulation because of textual literalism.
We moved through a disputed presidential election decided by a ticking clock.
We saw campaign finance rules shattered in the name of the First Amendment.
We watched the Voting Rights Act lose its teeth over outdated data.
And we felt the earthquake of Dobbs erasing a 50-year right to bodily autonomy. In every single case, a single swing vote fundamentally altered the American landscape.
The power of one vote. It reminds us that the law is not just a dusty book sitting on a shelf.
Right.
It is a living mechanism operated by human beings with distinct, powerful philosophies about how this country should be governed.
As we wrap up this deep dive, I want to leave you with a final provocative thought to mull over. Something that builds on everything we've discussed today about the court and the legislature.
What is it?
If the conservative defense is right, and the court is simply doing its constitutional job by reading the text strictly and handing hard questions back to elected legislatures. But those legislatures are so hopelessly polarized or paralyzed that they refuse to pass laws, update data, or solve modern problems. Are we unfairly blaming the Supreme Court for doing its job? Or are we actually witnessing a constitutional system that can no longer function when Congress refuses to do theirs? Is the anger directed at the Supreme Court really just misdirected anger at a broken gridlock democracy?
It is a question that requires you to look beyond the 9 justices sitting on the bench and look at the health of the entire republic.
Thank you for joining us on this deep dive into the underlying forces shaping the highest court in the land. Keep questioning the headlines, keep looking at the underlying philosophies, and keep exploring the world around you. We'll see you next time.